A will is a legal document that specifies how a person's immovable and movable assets should be distributed and managed after their death. According to the Indian Succession Act of 1925, any person of sound mind who is at least 18 years old can create a will concerning their property. The will must be made voluntarily, without any coercion or undue influence. If desired, the person can declare it to be their final will. The will should include the full name, address, and identification details of the person. A will becomes legally effective only after the person's death, meaning it takes effect only upon the death of the testator, who is the person making the will. A person can only make a will regarding properties that they legally own. For example, if a husband includes instructions in his will regarding his wife's property, specifying how it should be distributed or managed, such provisions would have no legal effect. When a person names their children in a will, they must include each child's full name and state their relationship to them. For minor children, the will must designate guardians or other suitable individuals to protect and manage the property until the children reach adulthood. Under Section 63 of the Indian Succession Act, a will must be signed by the testator and 2 witnesses. Anyone who stands to inherit from the will cannot sign as a witness. Although the registration of a will is not legally required in India, it is advisable to register it to prevent future disputes. An executor may be appointed in the will to implement the instructions after the will comes into effect. The distribution of assets among children should be clearly specified in the will. In certain cases, a husband can specify in his will that, if the property is in his name, his wife may reside in the property for her lifetime without transferring ownership. After her death, the children would then have complete freedom to take possession, mortgage, or sell it. In essence, a will provides clarity on how a person's property should be handled after their death. If changes are needed after making a will, the initial will can be revoked and a new one created. The most recent will made during a person's lifetime holds legal validity upon their death. If you found this video helpful, please like and share it with others. Subscribe to our channel for more legal insights.